talking about estate planning, there's so many contingencies that are difficult to plan for in agriculture, and everybody knows that. There's a lot of risk and a lot of uncertainties. The funny thing though with estate planning is people, for I think a lot of psychological and economic reasons, put it off and resist getting it done or resist even thinking about it, which is ironic because it is, of all the contingencies that we have to plan for in ag, between trying to figure out inputs, trying to figure out prices, trying to figure out how, when, and what to hedge. You're dealing with uncertainties, you're dealing with things that aren't going to happen. This is the topic we're going to talk about. When you talk about estate planning, you're talking about preparing for the one contingency that is a certainty, and not just in ag, but in life in general. So the one thing we know we're all going to do is die, and I think specifically because it is a difficult thing to think about, just like nobody likes to plan their funeral, it's no fun to plan ahead for this either, but it is critical for both for your operation and your loved ones and the continuation, particularly if you want to continue your operation on through to the next generation, to really think about these issues and give them some time and make sure you get a plan in place. And I think I'd start by saying, and I think we'll close by saying as well, that the most important thing to do as you think through these things, there's a lot of different thises and that's to think about. Every operation is going to be different, so there's specific and unique needs in every operation. But it's critical that you find a starting point, start thinking about how you want things to go, and just start somewhere and do, like any job, start somewhere and don't be intimidated by it, because if you don't start, you'll never start. So we're going to talk about estate planning in general today. We're not going to go super in depth because we've only got an hour here, but we do want to talk about a lot of the big themes and things that the big picture things as far as the options you have and things that you should think about as you prepare to put a plan together moving ahead. It is important, obviously, that you find a good attorney that knows what they're doing when they do estate planning, particularly now in agriculture where with values going the way they have for both land and inputs and everything else, the amount of money involved and the tax liabilities, everything's gotten bigger. It used to be we could put plans together for people that were much more like planning for any other individual. It's now become much more like planning for a large small business to try to figure out how you're going to put the succession plan together for any kind of ag operation. And that's particularly true if it's going on to the next generation. So with that said, I'm going to turn it over to Connie to talk about the first set of our slides here on why should you plan now as opposed to plan later or never plan, which is I think a lot of folks are planning to never plan.
So I think all of us kind of breathed a sigh of relief at the beginning of the year when we were scrambling, at least we were scrambling, trying to get some planning done before the end of the year when the tax picture was going to change. Everybody said the tax picture was going to change. And then, in typical fashion, Congress acted at the very last minute and changed things to say that they're staying exactly the way they have been. So, a lot of times I will see people come into the office, and this is the exact reason that they're coming in, is for taxes. And it's a very legitimate reason. Obviously, none of us want to pay more to the government than we have to. But I think that it's worth saying and emphasizing again throughout the presentation that taxes are not the only reason to be planning. In fact, as we usually get in and start talking to people about their specific plan, taxes kind of become they go to the back burner. They're always in the plan, and we work through those issues. But really what becomes more critical and to the forefront in any plan is how are the relationships involved between all the people involved in the operation. And what we're trying to preserve is that family relationship and the ongoing operation of the farm. And so that, talking about how that actually works and getting a plan in place that will actually take into account all the personalities, all the different involvements, and things like that is really critical. And it takes time and can be detailed, but it's an important thing to think about. And as Brent said, we see a lot of people that the plan seems to be not to plan, and if you have not put a plan in place, the state of Missouri does have a plan for you. It's called the intestacy laws, and basically what happens is that it's all laid out in statute where your property will go. And most people we see want to leave their property to their spouse. Almost especially if they're in a first marriage situation, the property should be left for the spouse and then to the kids. But that's not actually the way it's laid out in statute, and most people aren't aware of that. But there is a plan in place, and it's usually divided between the spouse and the children. So, something to be aware of. The other reasons to plan are if you have minor children. If you have minor children, there are plans in place as to what will happen most with the property, at least. The plan is generally that at age 18, they're going to get a big check. And that may or may not be a good idea. It's usually not a good idea. But if you haven't taken the steps to actually think about, well, what is a good idea? When should we give them the money? Should we give it to them spread over a length of time? Should we make them a co-trustee and get them involved in the operation? Or how should that work? Then what happens is if something happens to you, you have minor children, the judge will step in and they will appoint a guardian, which may be a fight between your family members. And the judge will step in and they will say, okay, you have property, but we didn't have any sort of plan in place. So what happens is it basically is held as a minor's account and it gets distributed at age 18. No questions asked. So another big reason we are seeing more and more of is in the second marriage situation. As long as everybody is still alive, all these things seem to be, it'll go smoothly. But in reality, this second marriage situation makes all the relationships more difficult. And if you are in that situation, you absolutely need to plan for it, because usually there hasn't been much communication and everybody's expecting something a little bit different, and it usually sets up a situation where there may be bad blood for, if something happens to one of the spouses, and then they have to have an ongoing relationship with the children of the other spouse. Heirs involved in the farming operation, if you've got on-farm heirs, off-farm heirs, which usually is the situation now, just trying to deal with how are we going to compensate the people who are in the children or grandchildren who are involved in the farming operation. What does that look like as far as passing that on to them? Do we want to get them involved now? All those sorts of things to be thinking about. And it can get involved, but if you don't think about it and really think how the plan will actually work, we've got the plan, okay, now let's think about what happens if this contingency happens and what happens if this happens, and really thinking through those details, and you vet the plan and make sure that it's going to work as much as you can, as you can see into the future. We make sure it works in all of those situations. And farming, as Brent mentioned, it's become a large business at this point, especially with the values that are of the land and inputs and machinery. And so, you really need to think about what happens. Do we want this farming operation to be viable and pass on to the next generation? And if so, how is that going to happen? You want to start here?
Yeah. So I wanted to talk about, and tying into what we just talked about, why should you plan now? The goals that you can lay out with an estate plan, and things that we always advise people to at least have as some of their primary purposes when they come in and put together a plan, and things to think about. Obviously, we're talking about taxes. One of the goals in any estate plan in the era of taxation and uncertain taxation now is try to find a way to minimize the tax liability for an estate. That's going to be at the federal level. The feds kept they kept the $5.25 million cap in place, exemption in place now for now. There's uncertainty in a lot of different directions politically. Obviously, the president has long said that he wanted to see it at $3.5 million. It may or may not roll back there, depending on how some of the fighting over, I think, entitlement spending and income taxes go. But even at the current number, and even with an inflation index mixed in, depending on what happens with commodity prices, you could at least temporarily, still see a lot of operators throughout the Corn Belt and even in Missouri, given land prices and given the prices of other goods, you can see folks having an estate tax problem if they were to die at the wrong time when commodities get high, or if commodities get high and stay high. Land values will likely go with it. So if you've got any kind of land in hand, and also, any asset you have in hand that you own to the extent you own it, you'll have a tax liability. And so we certainly look to minimize estate taxes as much as possible through a mix of vehicles and business organizations that we can put together for an operation. Another major goal of any estate plan that we put together now is to find a way to avoid probate court. So the way, and I should say a bit about what probate court is. When somebody dies in Missouri, whether they die without a will or even if they die with only a will, their will set out what's supposed to happen to the property they own when they're gone. But you still have to go through a probate process because the court has to look at that document and actually make the official awards of that property out to the folks that are supposed to get it. So they have to oversee the process of making sure the creditors get paid and oversee the process of making sure that the titles on any titled property are switched to the appropriate party. And you know, it now has become a pretty boring and dry process, but it's there in part because people used to settle these things with gunplay, and so we had to find a way that you could do it without gunplay. There are ways to avoid probate, though. We're going to talk more about some of those vehicles as our presentation goes on. And that for us, that's always something we try to encourage people to find ways to avoid probate whenever possible, because probate can take usually at least 9 months to a year, and that's often an uncontested situation. And in a contested situation where you've got family fighting or outside creditors fighting on down the list, it can take a lot longer. And it can really tie up your descendants' time, but it can also tie up an operations ability to even move forward and actually, you know, raise more food for folks. So that is another major goal. Whenever if you're going to take the time to put together an estate plan, you want to try to find a way of not having assets go through probate. We also look to find a way to try to tie in the business organization for an operation with an estate plan to as much as possible protect income and the security of your income and during your lifetime while you're still alive. That's where, you know, some folks, it's kind of like insurance. They think about an estate plan. They don't want to get one done because it's not their problem anyway. By the time, just like life insurance, the only people that will utilize it are people that will be there after you're gone. But there are some things on the business planning side that we can also do and tie into estate plans that can help protect your income for during the lifetime, and it's also, you know, it really becomes a second opportunity for people to go back and look at their operation afresh too, and think about the way various aspects of their business interlock as it relates to their income. And so there can be some other efficiencies that built in even when you got to go pay to have an estate plan done. It's an opportunity to put your house in order as far as your business organization goes in general. We always, a major goal obviously within the ag world is try to involve the next generation, because you've got multi-generational operations. You've got your farm is in place and has probably been multi-generational, or there's generations that have come before you, and I know many folks would like to have generations that come after them, and so that can be complicated in the modern day, especially when we often see situations where not every sibling stayed on the farm, so you've got to try to figure out how to deal with that issue when dividing up an inheritance. But we always plan, particularly because Connie and I do so much work that emphasizes ag operations, agribusiness, and producers. We always try to make sure we've got an eye turned towards how can we make things go as smoothly as possible into the next generation in transition. Another thing we always think about, and this kind of goes back to the third point on income security, is tying together a plan, or at least thinking about how you take care of long-term care needs. Especially, some folks come to us, by the time they've come to us to look at a plan, they're already in need of long-term care, and that makes things more complicated. But if you can back up, you may be 20 years out from needing a long-term care solution, but there's things you can do within your estate planning to begin to plan for that and make that a smoother process as well, and a cheaper one in the long run. This one goes back to involving the next generation. We want to find a way, whenever we plan to, it can be a difficult and emotional subject. We want to find a way to avoid family conflict. The problem sometimes on the front end is you have to have a little bit of conflict on the front end so that you have a lot less on the back end, and that makes it difficult for people because you always want to put off today what you think you can do tomorrow. But like a lot of other things in life, when you do that, the thing that happens tomorrow can be a lot worse than what you had to deal with today. So we do try to always make sure that we have an eye towards minimizing conflict within the family, keep everybody together before and after an estate plan is in place. Again, this is in keeping with involving the next generation. We always want to make sure we plan with an eye towards keeping an operation going and developing succession steps in each individual situation that will make sure that the farm can keep moving as it has, can remain profitable, that it doesn't get completely hidebound as far as how it has to operate. There's wrong ways and right ways to do the succession down to your children, down to your descendants. That if it's done the wrong way, it can really cripple an operation because you can't get consensus to move ahead with the business. If it's done the right way, it can go a lot smoother. We want to make sure that there's a proper transfer of assets on death, and this is the whole reason that we have probates and wills and trusts and the succession plan to begin with, is that you want to make sure that your stuff goes to where you want it to go. The government has a lot of plans for where they would like it to go, and beyond just having, Connie talked about their plans for intestacy, which is the default plan that's in place if you die without a will. They've got a plan for you there, but also as it relates to taxes and fees and everything else, they've got a plan that may not be your plan. And so, and this also ties into things that are all the way down to the level of, you want to make sure your personal property goes to the exact people you want to see have it. You want to make sure that if you've got a plan for charitable giving in your life, that your money and your resources go to the places you want them to go. And so that is the other thing to be thinking about, is you think as specifically as possible about where you want your assets to be when you're no longer around. And that's the last point I have in this slide. Send your money where you want it to go, not where they want it to go. Now, Connie's going to talk about the property ownership elements of how we set up some of these business entities. I'm going to grab a chair here.
Some of what we're going to talk about is just kind of the things you need to be thinking about and gathering when you're going to talk to an attorney about doing your estate planning. What I would want to know is how the property as you currently have it is owned, because that will give me a lot of information as far as what do we need to do with it, and what do we need to do immediately, what do we need to handle as we put the plan in place, and where do we need to look, and all those sorts of things. So that is one of the things that you need to be gathering that information. So some things are held in individual names. Maybe you have a piece of property, literally just has your name on the deed, and those are kind of the ones that are the low apples we want to make sure we get taken care of, because if something were to happen to you, then that is absolutely a probate asset, and it's going to go through the probate court because there's no designation as to where it goes. Now, there are other ways of holding property that may have some type of plan for what happens to the property if something happens to one of the owners. And we're going to talk about these. And some of these are used a lot in estate planning as the whole estate plan. And we'll get into this, but some of them are pretty blunt tools to use, meaning they work as long as everybody dies in the right order and as long as nobody's fighting. But if your plan gets complex and you want to get this party involved in this way and this party involved in a different way, they make this, just the way you title the property is probably not going to get where you want to go. So I just want you to be aware of that as we talk through these. Did you take the clip?
I did take the clip, sorry.
So joint ownership is basically, there are a couple different ways of holding property when we're talking about joint ownership. One of them is joint tenants with right of survivorship, which is very technical legal jargon. But basically it means that if two names are on the piece of property and one of them dies, then the other named person on the property gets the whole thing. Or tenants in common, which is really the other common way of holding property as joint tenants. And what happens there is that if one of the owners that's named on the piece of property dies, then that piece of their property actually passes on to their heirs, and the other owner still owns their half, or however it's divided. So it's very different, and the really sneaky thing about this is you can't always tell by looking at the property how it's titled. Sometimes there's hidden words that will tell us, like if it says Sue and Bob as husband and wife, that gives us a clue as to how it's actually titled, but you looking at that deed cannot tell, is it a joint tenancy, is it tenants in common, or is it there's a third one actually too, so I'm getting far afield, but there's all these things that are tied up and that we would look at and see how is your property currently titled and how do we need to, maybe we need to leave it the way it is or we need to change that, so. Beneficiary designations. There's a whole world of non-probate transfers is what it's called. So, we've talked about avoiding transfer as a big part of what we want to do with your estate plan. And there are ways that you can avoid probate which do not involve wills, trusts, all those sorts of things. So when you go to the bank and you have, a CD, you actually list beneficiaries on that CD. And when you do that, that is basically a contract with the bank that says, okay, if something happens to me, you pay these people in these percentages. And that won't go through the probate court. Same with if you set up an IRA, if you have an investment account, a lot of times you're filling out a beneficiary designation and, a life insurance policy, you fill out a beneficiary designation. And those are all contracts with those companies that if it's Edward Jones that you have your IRA with, that's a contract with Edward Jones, and they have in place what happens when something happens, when you pass away, and who gets paid. So those are all passed outside of probate. Same with POD or TOD, they're kind of used interchangeably. They just mean pay on death or transfer on death. Those type of designations, which are often on bank accounts or on vehicles, those will all pass outside of probate. And then we're going to talk about trust. Now, those that I've kind of covered, these non-probate transfers where you've got joint ownership, you've got some type of beneficiary designation, you've got a POD, those all absolutely work. And if you have a very simple plan, that may be the best way of dealing with it. But we have seen many times where that type of plan has kind of gone awry. They have a beneficiary deed on a piece of property. It lists all 5 children. Well, you haven't really solved any of your problems except that you avoided probate. Now all 5 of your children own a piece of property together, and the fight is on. I mean, it's just postponing the problems in a lot of ways that need to be dealt with and talked about in building your estate plan. Trust, which we will talk about in more detail, are kind of the tool of choice for avoiding probate and putting a very specific plan in place. And so that anything that's held within the trust or payable to the trust avoids that probate process, and we can get a lot more detail as far as how it gets transferred. You want to talk about that?
Yeah, and I just want to talk about some of the unique, while we're talking about anticipating and planning, there are some unique challenges for farm and ranch operations, as you can imagine, like everything else in this business, that we do have to think about as we put together plans that touch on those issues that are different than the plans we'll put together for just somebody who comes in and has a little bit of property and a couple kids, and they want to make sure that they know where all that's going. One of the biggest issues, obviously, and this goes to tax liability and everything else, is you're dealing with an unpredictable income and growth in terms of your net worth, just because so much of agricultural net worth is tied to land. If you row crop at all, or I know obviously lots of folks here today, hog producers, if you're row cropping, even for a hog operation, as everybody here knows, real estate is a major piece of your net worth, the extent it's paid for and where it's priced. It's a very movable number. We've seen a big run up. We all know you can see a big run down, and so that makes it a tricky process to try to figure out where you're at in terms of the long-term prospects for your tax liability, even putting aside the unpredictability of the political situation. And that is something that has to be considered as you plan and as you think about what things are going to look like in 10, 15, 20 years. And I've talked about land values. The other major problem, or major, it's not always a problem, but it is a major issue to think about in agricultural businesses, is multi-generational involvement. It's become very common for us now as we help folks plan. A family will come in that's got 3 or maybe even a 4th generation on the ground that's looking forward to being involved. And so you've got, parents, you've got the oldest generation, their 70s and 80s, with kids in their 50s and 60s, kids in their 20s and 30s, and sometimes then even kids that are 5, 10, 15 years old. And you're trying to figure out exactly, you've got to think about who is going to be involved, to what degree are they going to be involved. And you've also got the other major issue we run into is people try to figure out how to do a fair versus equal distribution over generations. It's, the boomer generation, especially the late boomers, as farms have been consolidating throughout the 20th century, gotten smaller, usually not every sibling stayed. And so lots of families that come to us will have 1 or 2 brothers that stayed, or a sister that stayed. They'll have 1 or 2 brothers or sister that left, and may live far away or even out of state or even out of the country. And, the degree to which somebody who's still involved in the operation has put sweat equity into the current asset makes it complicated to try to figure out. If you just went and did a straight 3-way or 4-way division, you're really not going to be taking care of, on-farm siblings who have their livelihood maybe wrapped up with the asset, compared to somebody who, left at 18 and didn't come back, left at 20 and didn't come back. With that also comes the issue of keeping the land intact once you when somebody's passed on and we've done a distribution. Seen lots of situations where a family will decide to give land away equally, or even give a proportion of land to an off-farm sibling. Off-farm sibling decides they need their cash today because they aren't involved in the operation and they want to move on with it, and suddenly their siblings are still farming, they can't finance it, they can't pay it down, so they sell it to an institutional investor or a different neighbor. And meanwhile, the brothers that are still there will have loans out on equipment and will need that much land to justify the equipment loans they have. So that sort of scenario plays out far too often, and there's ways that it can be avoided if people will plan ahead, and you won't end up with this. It's one more situation that creates a lot of conflict and tragedy, and it can be avoided, but that is a major issue with ag operations, and really we see it in other types of small businesses that has to be thought about in a way that you can't lots of folks that live in town can just take all their assets, sell their house, and give it to their kids in equal portions and call it good. You can't do that in a farm operation. And I've talked about the equal versus fair issue that goes with that. There's also issues associated with multi-generational involvement as to control and how the control of the asset will move forward. We see lots of families that maybe a sibling, an off-farm sibling, wants to keep an ownership interest in the farm, but you don't want them to have a managerial interest because they don't want a managerial interest, or they're not competent to have a managerial interest in what goes on with the farm. So they could be a non-voting investor or however you want to. There's different ways to arrange that. But that is another issue that we've got, and really I've been using the simplest example, talking about a few children for a parent that's died. Now we're seeing you've got a few children and their children, and the boomers that have kids that want to get involved will have one or two kids of their own that want to stay involved, and one or two that have left. And so trying to dig to the bottom of that obviously can get to be a pretty complicated web very quickly. And it takes some thought to figure out exactly what you want the control versus ownership aspects of the operation to look like. But it's critical to do that ahead of time when you're not in an emergency situation, rather than just to toss it into the winds and hope it shakes out at the end. Because that really is when families get completely sideways and people don't talk at Christmas anymore, and all sorts of things that we really want to avoid as we move forward.
You're still up.
Oh, am I going to read this cartoon?
You don't have to read.
Okay.
You are going to talk about taxes.
Okay. In case you can't read it, it says, go back. I don't know if it's showing up very well up there. It says, relax, I'm from the IRS. Death and taxes have merged, which is becoming truer every day, I'm afraid. So I did want to talk about taxes quickly. I know we've talked a lot about tax liability, the various kinds of taxes that we're going to deal with and that are important in consideration in an estate plan. Estate taxes obviously have been on everybody's mind all through last year, as we all wonder what was going to happen to the Bush tax cuts on the estate tax. At the 0 hour, for now the exemption has been kept at $5.25 million per person, and that actually under the current law works out to a $10.5 million exemption per couple. There is a portability statute in place that says if one spouse precedes the other in death, their exemption can be imputed to the deceased spouse exemption can be imputed to the living spouse. So it effectively works out to be a $10.5 million exemption. Now, I mean, the good news is that's 5 times better than it was. The bad news is, depending on where you own your land in this state, if you own land in the Mississippi or Missouri River Valley, it doesn't take too big of a farm right now, the way land's going, to still go ahead and jump over the fence on that one, especially if you add in not just land, but it's any asset you have either or even partially own. I mean, even if you have debt on a certain asset, anything you actually own outright goes into your net worth. That number goes in, so it's land, equipment, anything you own will be figured in by the government when they figure out whether you have a estate tax liability or not. So there are ways that we can plan to try to minimize that, including, I'll talk about gifts next. I mean, gifting is a big way We at least encourage people to try to minimize their net worth every year by gifting to the extent that's appropriate within their family. The gift tax is folks at one time, like always with taxes, got real clever and they just started trying to give everything away before they died to avoid a state tax, and the government got wise to that, so they put a gift tax in place. And the gift tax is there so that if you give property away during your life, it starts to, you have a $5.25 million lifetime exemption on your gift tax as well. And so if you go ahead and you gift all that away, they'll just go ahead and it eats at your estate tax exemption, and so the government's going to get theirs one way or another. Now, of course, they didn't want to go tax every Christmas gift there ever was, so they put an exemption in place that's slowly gone up over the years. And the exemption right now is $14,000, and so you can gift up to $14,000 a year. You as an individual can give $14,000 per person. So if you've got 3 kids, you can give 14 grand to each kid. If you've got 20 grandkids, you can give 14 grand to all 20 grandkids. And stay below that without ever cutting into your state tax exemption. That makes this a pretty powerful tool for folks that are fairly close to the line. If they're, if you're a little bit over the line on your estate tax exemption, you're afraid if you die today, you own too much, you own enough property, the government's going to come and tax some of it. It allows you to then go back and give out money in $14,000 chunks. And if you've got enough people you like to give money to, you can get down under that ceiling fairly quickly, as long as you're not way over. I should say on the estate tax, the rate did come down. Well, it came down from what the proposed rate would have been if we'd gone back to the old law. We were going to revert to a $1 million exemption with a 55% rate, which means any property you owned over $1 million or over $2 million as a couple was going to be taxed at 55%. It's now come down to 40%. So anything that you own over $5.25 million as an individual or $10.5 million as a couple will be taxed at 40%. It's still way too high and way too much to give back, but it is better than it was, I guess we can say at least. The last thing of the actual estate type taxes, there's the generation skipping transfer tax. This is another place where folks got pretty smart. They tried to give their money straight to their grandkids, and at least then the money would skip one generation one set of deaths before the government put their hands on it. The government figured that out and put in a generation skipping transfer tax it's the same exemption. It's a $5.25 million exemption, and they'll hit you at 40% there. So if you go ahead and send your money down to one more generation down, they're going to go ahead and take their pound of flesh. The last tax on the tax slide I want to talk about is just the income tax. I think that's well understood, and we'll go real in depth on that. But income, the flow of your income tax in and out as it relates to money coming in and out from your ownership of assets within an estate plan is something that actually can be, because a lot of times in an estate plan we'll even change the status of ownership for the living today to make sure things are lined up correctly. It can change the flow of income tax and back out to the government because you change the ownership equation and you change the income equation coming back in. That actually is a way that estate planning can tie into more general business planning to create some tax advantages even while you're alive. If you think about the way you want to title your assets, it makes sense to give some of them away so that the income can be imputed to a minor that doesn't have income or another relative that doesn't have as much income. In the aggregate, it may be a way to keep some money away from the government that way as well, which I have the built-in assumption now everybody wants to do that. If somebody doesn't, I'm sorry, I don't want to offend anybody today, but they'll take a check. Even if you want to send some in just for fun, they will take a check for that as well. But I haven't wanted to do that yet myself. But Connie's going to talk about the actual tools of estate planning now and the nuts and bolts.
I actually did once have a client who wanted to use part of his estate to pay down the national debt. And we did that. We put the provision in his trust, and then he changed his mind in 6 months and said, I don't think they're going to get any better, so let's just do that. Anyway, we're going to go through these really quickly. I just kind of want to, this is kind of basic, and you guys may have a familiarity with this already, but I want you to know what attorneys are talking about when they're talking about these various things and kind of how they fit together. So I'm going to kind of quickly move through these. The first is the revocable trust. And this is kind of the main sort of, honestly, in probably 95% of estate plans at this point, I'm using a revocable trust. And you hear it called a lot of different things, a living trust, a revocable living trust. And sometimes they have really fancy names for them that, they've tried to patent, or, you know, it's just kind of crazy. But what they, whoops, I went too far. There we go. Okay, so the basic thing on this revocable trust is that it can be changed. That's the whole deal with it, is that you can go in and you can change any provision in it that you want during your lifetime, and it makes it kind of it's really the main sort of planning tool, and you can change any of it, and really work, it just kind of lays out the whole pattern and becomes kind of an organizational tool for the whole estate plan. The other good things about this is that it is private. When all you have is a will, that is actually filed with the probate court and is public record. So a trust stays outside of that process and is never, you know, it's never subject to public inspection. So if you want to keep private kind of how your affairs have passed, this is the way to do it. And the other nice thing about it is a will never does take effect until your death. And so with a trust, you can actually put provisions in place that if you're still living, but incapacitated and not able to handle your affairs, who would step in and take care of these things, and how does that work? So you can do all of that through a trust. We already talked about some of the rest of that. Just some very basics here is that in a lot of ways it becomes a replacement for a will, because one of the things it does contain is what happens to, you know, what happens to my property upon my death, who does it go to, how does that look, does it stay in trust for, you know, minors, all those sorts of things. And also, I think some people are really hesitant about doing a trust when they come talk to us, because they want to know, how does that change my tax picture? Can I still get a loan on the property? Can I still sell the property? All of that stays exactly the same. When you put it into a revocable trust, which is what we're talking about here, you can do exactly what you did with it before. It all flows through onto your individual income tax return. So when you sell your piece of property, you may have to sign off as trustee, but you're still going to do that. You can still get a loan on it. All those sorts of things. And when we do a trust, we usually pair that with what's called a pour-over will. So we don't completely get rid of the will, but what the will does is just kind of become a backup document, and what it says is, all the property that I didn't get into my trust or was not payable to the trust upon my death, I want to take it and dump it into the trust. So that's how it got its name, a pour-over will. So the way this works, and this may be really basic, but I want to go through it because I always see some confusion on it, is that what the trust is that you literally come in, we get the document the way you want it. It says what happens during my lifetime, what happens upon my death, and all the what ifs as far as what if I'm incapacitated and not able to handle my affairs. We get that all in order. It's one document. Or, sometimes we do a separate trust for each spouse, but a lot of times we'll do a joint trust for the married couple. And the document is signed by the creator of the trust, which is called the grantor or the settlor. There's all these confusing terms. And that is what actually becomes kind of the trust. That's what we're referring to. And then within that, you're appointing somebody to take care of the assets that you actually transfer into the trust. And that's what's known as the trustee. And usually what happens is during your lifetime, you were the trustee. You can move property in and out. You can do anything you want with it. And so you act as trustee. And it's really only upon, if at some point you decide you want help with a lot of times I'll see people who are getting older and they want to have one of their children step in and just help them with things, and so they can have them step in as co-trustee with them maybe. Or if they become completely incapacitated, they can step in as the sole trustee, and then obviously upon death that other named trustee will step in too. It's a very seamless process because it's all laid out in the document and there's no question as to who steps in and does that. And I've kind of covered the rest of this, but and when we talked about the fact that it's revocable, you can change it or completely get rid of it at any time. And I'm going to go through this pretty quickly. A will is not effective until your death, and it does not avoid probate. This is a very common misconception that we see is people will come in and say, I have a will, I'm all set, and it may work. It will work, but it won't avoid probate, which I think is kind of a common misconception, is that we won't have to go through the probate court because we have a will. All the will is directions to the probate court as to what happens to your property. And we talked about the pour-over will when it's combined with a revocable trust. It just dumps everything into the trust. One thing that the will does do that I didn't mention is that that is the place to name a guardian if you have minor children.
Another major piece of what we do with, the trust and will side of the planning goes to the movement of your property upon your death. There's also incapacity and end of life planning that's important to do anytime you get a will set up, and especially get it all done at the same time while you're thinking about how you want these things to work. Another document that we will set up anytime we put together a basic estate planning package for people is a durable power of attorney. The durable power of attorney just allows you to name the person and the conditions under which somebody can take over and handle your finances. Usually it'll say, upon my incapacity, I want person X to take over and be able to take care of my financial affairs. And then we'll actually set out a chain of people who will take over your affairs based on a contingency. Because most durable powers of attorney, people will name their spouse or a child. But if you were to die in a wreck together, which obviously happens, it lays out the order in which each successor power of attorney can step in. And so it'll say my spouse, and then my whichever child is closest or most responsible, and on down the list. But that is something that's important. And so the durable power of attorney names the person who's going to handle your financial affairs. And I've got and you can make them effective. You can actually make them effective immediately. Even we have folks that come in that are, if they've reached a point where they think they're near incapacity, or they've got a serious health problem, or they're just tired of having to write their own checks and they have a child they trust, you can name somebody to be your power of attorney effective immediately, but often it'll be upon disability or incapacity that you name somebody to go ahead and take over your affairs. And you do want to be careful with these. They tend to be very powerful. I mean, you normally are giving somebody omnipotence when it comes to dealing with your finances when you set these up. We can write conditions into them, but to make them actually work when you're incapacitated, obviously, somebody's going to have to take on full power, so it better be somebody you trust. The other thing we'll set up is a healthcare directive. You'll often hear these called living wills. And all that really is a directive to a hospital or to caregivers and to the court, so they can enforce it if there's a controversy that says, under the following conditions, I want whoever you name, I want person X to take over and make my medical decisions for me. Again, it's normally incapacity, although you can, even while you're still lucid and awake, if you just don't want to make those decisions anymore or don't think you'll make good decisions, you can turn those over to somebody else. The living will can even be set up where you just give directions to the hospital for like a do not resuscitate. But normally you're going to name somebody and say, this is the person I want to have make my decisions. Also within the durable power or the healthcare directive, you will set out the instructions for when to pull the plug. And different people have different conditions as to when they want that to be. But most people will set out the language that says, under the following conditions, I no longer want to be on life support. And that document all rolls together. And so you name who's going to take care of your affairs medically, make your decisions, and when you no longer want to have medical care. And again, you want to carefully consider your agent. You want to have somebody who's going to make sound decisions, and hopefully ones that aren't completely driven by financial interests. So which can be an issue. Connie's going to talk about irrevocable trust now.
So we talked about revocable trust, and now we're going to talk about irrevocable trust, which all that means is that you can't change it. Or it's a lot harder to change. It's not a complete bar. Sometimes we try to build in as much flexibility as we can, but a lot of times they can only be changed with the court. You're actually going to the court and changing the provisions of the trust. So they're a lot more inflexible than a revocable trust, but in certain situations they're exactly what we want to use. So we kind of use irrevocable trust in very specific sorts of situations. If we're talking about a gifting plan, Brent kind of alluded to that with the annual exclusion gift. You can't make a gift into a revocable trust because, as we talked about, that's still treated as your property. Everything flows through on your individual income tax return. You can pull the property in or pull the property out, put it in, all those sorts of things. And if for the government to consider that you've actually made a gift of the property, you have to release control of it And so you have to set up this separate entity, which is this irrevocable trust, which you can then make a gift into, and that would qualify as a gift. And so when we are talking about, kind of long-term gifting plans, we use an irrevocable trust, and you actually make a gift to that trust, and it allows it to qualify for a gift. But if you have minor children, or there's a lot of situations where we'll set up dynasty trust, where we can take advantage of that generation skipping transfer tax. And if you put the property in and it goes on for the lifetimes of several generations, you can actually skip that estate tax over the course of many generations. So the other time we'll use it is when we're talking about paying for long-term care. All of these are kind of a whole other session. I mean, they get really complicated, but they are used in very specific and very useful sorts of ways. The other one is it's called an ILIT, an irrevocable life insurance trust. And a lot of times we're using insurance maybe to fund some part of the estate plan, maybe to basically pay a portion to that off-farm heir. And so rather than actually the client owning the policy outright, what we'll do is we'll set up an irrevocable trust for the sole purpose of owning life insurance. And what that does is if you set it up before you buy the life insurance policy, it never becomes part of your estate. So if you buy a $3 million life insurance policy, if you owned it outright, all of a sudden you've just inflated the value of your estate by $3 million. Whereas if you buy it you set up this ILIT, the irrevocable life insurance trust, and you have it buy the life insurance policy, it never becomes part of your estate, but it can still be used for those very same purposes as far as working through your estate plan and funding a part of whatever it is that we're doing. But as we talked about, they are fairly inflexible, so they should only be done with very careful consideration. Do you want to start?
Yeah, I think the last thing we'll talk just quickly here, and then we'll take some questions about business entities. There's lots of different ways you can corporately organize in Missouri. I know, obviously, for most folks, for years and years, most farms were just set up as sole proprietorships, essentially. And as lots of folks, I'm sure in this room know, corporate agriculture generally in Missouri is illegal. But there is an exception that a family farm corporation can own and engage in production agriculture, and Missouri's law is fairly flexible on that, thankfully. Unlike a lot of states, that's a very specific type of entity you have to set up. In Missouri, you can set up any one of these other traditional types of entities, a partnership or an LLC or a corporation, as long as you go and it meets the other conditions necessary under state law, and you register with the Department of Ag. You can have a basic corporate structure that's just registered as a family farm corporation. We're often using within estate plans now, setting up and spinning out LLCs, in part because it can create some barriers to liability. It doesn't fix all your liability problems, but it can help immunize certain personal assets from tort liability. So, if you've got somebody goes and runs over somebody else, one of your employees runs over somebody with a truck, they don't take everything you have; they only take part of what you have, which is better than nothing, obviously. The other major way we're using a lot of these are tied to estate planning now is that we'll spin. When somebody wants to go ahead and figure out the way they're going to divest their operation, either while they're living or after they've passed away, an LLC can be a very flexible tool, or other corporate organization forms can be a very flexible tool where you set up percentages of ownership so that whatever that asset is worth on the day that it transfers, you can assign various ownership percentages, as opposed to having to say, so that you can roll 100% of the value of your operation there, as opposed to having to say, I want Jimmy to get the 2-ton truck, and I want Bobby to have the horses, and I want Billy to have the cows. Instead of having to deliberately set out certain assets, you can roll it up into one corporate entity and then just give everybody an ownership interest. That makes it for a very powerful planning tool, and you're seeing more and more sophistication, obviously, in the ag sector on this, in part because there's enough money now in a lot of operations to justify a more sophisticated planning. There's certain things that, well, this slide is talks about why we do it. It gives you a different organizational structure. It can help limit your liability, and it can make the transfer on your debt easier just by laying out percentages. There's certain things it won't do, though. It won't fix everything. You still have, the day-to-day managerial side of, like, some people have a misconception. You set up an LLC and suddenly, the business will just run itself, and it doesn't do that. And it doesn't protect you from all liability. If you've got personal liability, for example, if you're driving your own truck for your own LLC and you run over somebody on the highway, if you're personally negligent, they still can go ahead and come after your personal assets. So it doesn't fix everything, but it can help with employee liability, and it can create, and it can also help create a wall between the personal assets of multiple owners of a farm. If you got several brothers or several generations of people owning it, it may, that liability will go to one person's personal liability if they were the one driving the truck, but it doesn't. Every other brother, cousin, and uncle doesn't lose all their assets as well, or lose the whole farm because of this because of the actions of one person who's involved. So there are some other advantages in incorporating that go with it. There are some disadvantages. I don't think we've talked about them in these slides. They can be a little bit more complicated to manage just from the tax and accounting side. I mean, there are more sophisticated entity, and there are some additional tax documents you have to file. Normally, I think for the liability protection you get from these entities, it makes it worth it to do a little bit extra paperwork, but you should be aware it doesn't. There are, like everything else, there are transactions costs involved in having a corporate entity. So, okay, we're going to stop here because we get a little further in the weeds, and we did want to have some time for questions before we stopped. And the last thing I will tell you before I take questions, I do want to close, because this is pretty dry, but I do want to close with a story, because there's a human element in all this to think about, and there's something to think about within all of us philosophically, theologically. It's part of life. We don't like to look death in the eye, but it's really necessary. And the story I usually will tell when we do these presentations, I had a friend in Kansas that went to go do some estate planning for a family. He got a call from his son, and they said, "Come out. We want you to come out. We've been really thinking it's time to get something done on the planning." And so he rolls out to their farm and goes in and steps in the kit, knocks, and they said, "Come on in." And he goes in the living room. There's a guy standing there that's about in his mid-70s, and he said, "Well, hey, I'm here to talk to you all about your estate plan. Your son called and said that he wanted us to come out and sit down and talk about all this." And he said, "My son?" And he said, "Yeah, your son called." He said, "Well, I don't have a son." And he said, "Well, sir, I think your son called me." And he said, No, hang on just a second." And he yelled in the other room, said, "Dad, come in here." And his dad, I was in there, is about 98 years old. And he said, "We thought it was about time we'd think about this and get something done." And so in central Kansas, as old Czech farmers live forever. They live to be about 105, but even so, you want to make sure you get to if you're wondering if it's time to think about it, it is time to think about it. Anybody, if you're at the point where you're either married or you're married and or have children, even if you don't own a lot of assets outright, it is time to get a plan in place. At the very least, one thing we didn't talk about today, if somebody's got minor age children, one other document we always put together is a list of where the kids go. And that's something that's really important to think about. Who's going to raise your kids if you're gone? Because that's obviously the most important job you have, even above and beyond